Hello folks, this is Michael Lowe. I'm back again today and I want to talk about the most popular question that people ask me every day when they call me on the phone. When the police call them and they say, hey, come on in, we'd love to have your statement for this case, get your side of the story. So what we're going to talk about today is why you should not ever give the police a statement when the police call you. Now today I want to restrict my comments to state cases, not federal cases. And the reason why I want to do that is because state and federal cases are both investigated differently and they're prosecuted differently. In a federal case, there's a federal agent who does a different level of preparation, and then a prosecutor gets involved before the case ever gets filed. So there's a different procedure that takes place in a federal case. So today we're just going to talk about state cases. In state cases, typically what happens, say in a sexual assault case, a detective will conduct an investigation, and then when they've completed their investigation, at the very end, they'll ask to speak to the suspect of the case or the future defendant in the case. That's when you or a loved one may get the phone call, or a detective may show up at your place of work or at your house and want you to give a statement. At that time, my advice is uniform. I always tell people, don't give a statement. And the reason why I do that takes a long time to explain. So for those of you who don't have a lot of time, I'm just going to tell you, don't give a statement. And that's my advice that I'll give you based on 21 years of experience. I'm board certified in criminal law. I'm a former felony prosecutor. I've tried hundreds of cases. I've investigated thousands of cases, defended thousands, prosecuted thousands. All I can tell you is don't give a statement. Now, if you want to know the play-by-play, every single scenario that can happen, that's what this video is really for, and I'm going to explain it to you. There's something in game theory called a decision matrix, and that's what I've prepared. I'm not going to show it to you. You may see me looking down at my notes occasionally, but basically what that means is I'm going to go through every potential scenario that can happen in an investigation, and I'm going to explain why giving a statement or not giving a statement will impact the objectives that we want to accomplish during an investigation in a criminal case. So the first thing we need to do is define what are the objectives when I represent somebody in a criminal case just for the investigation part of the criminal case. Well, there's two objectives. The first and most obvious objective is to prevent the case from being filed. We don't want the police to file a case against the client. So that's a simple one. I think everybody can understand that. The second one is a little harder to understand for a lot of folks who are going through sort of an emotional roller coaster. And the second one has to do with the future. Do we want to allow the police to have a statement from the potential defendant in an investigation such that they can use that statement later in court? In other words, do we want the DA's office and the police to have a potentially incriminating statement? So the second objective is to prevent the police from getting an incriminating statement. So we have two objectives: no file on the case and no incriminating statements. Now, we also have to make two assumptions. The first assumption is, based on my experience, the police will not change their mind concerning probable cause. Once a police officer has made up their mind about probable cause, they're not going to change their mind. Now, I've been doing this for over 21 years. I've seen thousands of cases. There has been one case, I won't lie, there has been one case where I was able to show through extrinsic evidence, not through my client's statement, through other evidence, that the police had actually made a misidentification, and they actually recalled a warrant after they had made the decision for probable cause. That is a very rare case. Very rarely happens. Maybe you hear legends of that on the internet, but that's not real. So once a detective makes that decision concerning probable cause, and that's a real easy decision for them to make. Remember, probable cause is the lowest burden of proof in the land, so it doesn't take much to establish probable cause. Once they've made that decision, that's it. They're not going to change their mind. And typically what they do is they'll make up their minds and then ask the suspect to come in and give a statement. So that's the first assumption we'll make. The second assumption we have to make is that the detective is either lying to me when the detective tells me about the case, or the detective simply will not give me information about the case or will not give me any discovery about the case. And the reason why they do this is because at the initial phase of an investigation, there are no discovery laws that take place. There's something in Texas called Article 39.14. It's the Texas Code of Criminal Procedure. Some people call it the Michael Morton Act. And that act only applies when there is a quote unquote case. And a case has been shown to be something that is filed in the courts. It is not something that is in the detective's file before probable cause is established and a warrant gets issued. So the defense in an investigation has no right to discovery. So I have no way of knowing what's inside of the detective's file. And I can tell you based on my experience that detectives are trained to lie, and they are also trained to manipulate people into giving statements. So I make that assumption that I'm not going to be getting any quality discovery from the detective prior to my client giving a statement. And again, that they will not change their mind about whether or not there's probable cause. And then I guess in a way there's a third assumption, but it's sort of implicit in everything I'm saying here. The detective's not going to tell me if they have decided there's probable cause or not. They're not going to call me up and say, hey, Mr. Lowe, we've already decided that we're going to arrest your client and charge him with a felony, but we sure would like to hear his side of the story. They're not going to say that for obvious reasons. There would never be an incentive for the client to come in and give a statement in that scenario. And likewise, a detective isn't going to say, we have no probable cause in the case, but we sure would like for your client to come in. They know what my response is going to be in a situation like that. I mean, you don't need a lawyer to answer that question. So what I want to do is, given those two assumptions, I want to go through what happens if you give a statement, what are the different outcomes that can happen, and then go down and talk about what are the different outcomes if you do not give a statement. So we're going to go through each and every scenario. If you want to cut this video off a little short, I think you'll have your answer once I go through all the, I think, 5 different outcomes that can happen if you give a statement. I think once you've heard that part of the video, I don't think you'll have to hear the rest of it to know why I've concluded that you should not give a statement. But if you want to, we can go through every scenario and just keep watching the video. So the first one is what happens when you give a statement. And the first scenario we have to talk about is when the detective has already determined there's probable cause and you decide to give a statement, does that meet our 2 objectives, or how does it meet our 2 objectives? Well, let's talk about our first objective. We want to prevent a case from being filed. Well, if the client gives a statement, but the detective has already made the decision on probable cause and determined that there is probable cause, then we're not helping ourselves accomplish the first objective. So I would say we're either the same or worse with regard to the first objective. So there's no advantage there. With regard to the second objective, preventing the state from having an incriminating statement, we're definitely either the same or worse, probably worse. And the reason why I say probably worse is because of one of the assumptions I made was that we don't get discovery in the case. And in my experience in a criminal investigation, there's always going to be a few, if not many, many lies that are told to the police. And both myself and my client can't know what the lies are because we haven't been told what the lies are going to be. So more than likely, if you give a statement and the detective has already made probable cause, the determination in the case, then it's going to make the situation worse for the client. Now, if the detective has made a decision that there is no probable cause, hasn't told me that, of course, we assume that, and calls me and says, hey, have your client come in, and I say, sure, no problem, and I let my client give a statement, in that situation, we are either the same or worse. So how can we be the same? Well, if my client goes in and gives a statement and somehow doesn't say anything incriminating, then, and the detective has already decided there's no probable cause, well, then the detective continues to make that decision and there won't be any probable cause. On the other hand, it's more likely, in my opinion, that the situation will be worse for the same reasons I said before. We don't have discovery. There are many lies that have been told to the police. And so we're putting ourselves in a bad situation there because we don't know it, but the detective has already determined that there's no probable cause, yet we've given a statement, and now we may have established probable cause through the statement that we've given. So that's about 5 different scenarios right there on the statement. And as you can see, none of those scenarios is there an advantage to meeting our objectives. So, the objectives are case not filed, no incriminating statement in the future. We're not meeting our objectives by giving a statement there. So as you can see at this point, you don't have to keep watching the video because you know why I give this advice. There's no advantage to giving a statement in a criminal investigation. Now, some folks may say, yeah, but it just feels better to give a statement because I'm innocent and innocent people will go ahead and speak to the police. And that's kind of an emotional decision that people make. And that's something I have to talk to folks about all the time. And quite honestly, I tell people before they hire me on investigations that this is my advice, and I even put it out there on the internet for people to read and for people to see my advice. And if you don't agree with my strategy, don't hire me, because that's the way I do things, and I'm not going to change. So if you decide that you want to give a statement, but you want to hire me, then what's going to happen is you and I are going to have a bad relationship, and eventually we're going to split ways. And I don't want that. So I always tell folks up front, hey, this is the way I'm going to handle your case. Are you okay with that? And it takes some courage. It really does. It takes some character, because I think emotionally people do want to give a statement. They do want to tell their side of the story. But in that situation, there's no advantage to doing that. And I've just explained why. But let's go on to the other scenario where we decide not to give a statement. What happens if we don't give a statement? Are we meeting our 2 objectives? Remember, no case filed, no incriminating statement in the future. Well, let's go to scenario number 1 where there's probable cause. If there's probable cause and the detective has made that determination and we decide to not give a statement, have we met our first objective? Well, no, we haven't met our first objective, but honestly, it's the same situation because the detective has already made a probable cause determination. So we're not making our situation worse. It's just the same. Well, what about objective number 2, not giving an incriminating statement to be used against the client in the future? Have we met that objective? Yes, we have. So we are in a better situation than we would have been had we given a statement. So as you can see, just from the probable cause scenario, we're better off not giving a statement. Now, if we switch over to the no probable cause scenario and we don't give a statement, have we met our first objective? Case not being filed. Yes, we have. We have met our objective because the detective has determined there's no probable cause, and we have not given the detective any additional evidence with which they can use to establish probable cause by giving a statement. And this happens all the time, not from my clients, but I've seen other lawyers do it who are less experienced or haven't really thought this through. So we are meeting our first objective by making sure that the no probable cause case, the no probable cause case, stays a no probable cause case. That's the objective. Are we meeting our second objective by not giving a statement in the no probable cause case? Well, of course, the client's not giving an incriminating statement that can be used against them in the future. So we're meeting both of our objectives and we're better off for it. So as you can see, all of these different scenarios, how they play out, it's very simple. Don't give a statement to the police when you're being investigated on a state investigation. Now, as I said before, this can be an emotional decision, and that's why I wanted to lay this out in a very logical way. I'm more than happy to talk to you folks on the phone about this. There's a lot more we can talk about. Obviously, during an investigation, there's more to the case that I can do to help my client than simply telling them to not give a statement. For example, in a sexual assault case, there's a bit of an exception to the rule in a case like that, because typically detectives want my client's DNA, and I can force the detective to get a search warrant, and then I can obtain an affidavit from the court and get some additional discovery that I would not otherwise be able to get. So there are many things I can do other than letting my client give a statement. And of course, I can find other extrinsic evidence to prove my client's innocence, but we want to do that strategically. We want to give the detective only the things that can help us, and we don't want to give the detective anything that could potentially hurt us. That's how I handle my cases. That's the way I do it. If you like how I do it and you're interested in hiring a lawyer, I'm the person to hire. Thank you.